and thank you for joining us today. Before we begin, I'd like to introduce you to Gig Dooling, who's the Deputy Minister of Child and Family Services, and also Christine Osmond, who's the Director of Adoptions for Newfoundland and Labrador. It's my pleasure to announce today a new piece of legislation that focuses on the safety and well-being of children involved in the adoption process, which is Bill 27, an Adoption Act 2013. And I can tell you that this piece of legislation comes with a great amount of interest from, I know, our staff and stakeholders throughout Newfoundland and Labrador, and some of them are here this morning. So I'd like to acknowledge some of the staff from the Department of Child and Family Services who have joined us, and thank you for coming today. And I can tell you that some of the people in this room have worked on this and been involved in this process for a long time. So I'd like to acknowledge their work in bringing us to where we are today. I'd also like to take a moment to acknowledge my predecessor in the Department of Child and Family Services, Minister Johnson, who I know led this for a long time, and earlier this year when through the consultation process and working to get it where it was when I first came to the department in October. So I'd like to acknowledge her work and leadership on this as well. And also for stakeholders who are with us this morning, we appreciate you attending with us as well. This new adoptions legislation demonstrates our government's continued focus on the transformation of service delivery for children, youth, and their families. As a government, we recognize the importance of finding permanent and stable homes for children who cannot be safely reunited with their families. And therefore, we're proposing to replace the current Adoptions Act, which was proclaimed in 2003, with this new bill, Bill 27. In 2010, we brought forward the Children and Youth Care and Protection Act. And that was the first piece of legislation, that significant piece of legislation that was brought forward as part of the new department. As we continue to build a stronger foundation for the department, we recently began the review of our second piece of legislation, which is the Adoptions Act. Through public consultation process earlier this year, the department provided interested individuals with the opportunity to share their thoughts and their perspectives on current adoption legislation, as well as what changes were needed. During the consultation process, the theme of the best interest of the child was highly evident and very clearly heard, and it highlighted the importance of a number of functions in this act, including creating the permanency for children, and that's the function of the act, is creating the permanency for children, considering the connections and existing relationships in children's lives, as well as the child's opinion and wishes when planning for adoption, and as well, ensuring the child's safety and well-being in the adoption process. Overall, there was a strong support for those who participated in the consultation process for each of the proposed changes to the adoption legislation. As a result of the feedback that was received and our continued commitment to meet the needs of individuals involved in the adoption process, our government is proud to introduce this new legislation that will ensure the best interest of children remains the paramount consideration during the adoption process. And that's a value that's consistent with the new Children and Youth Care and Protection Act. So on updates for this legislation, the proposed new legislation will help streamline and expedite the adoption process. It will ensure that adoptive programs are progressive and clarify and modernize the law respecting adoptions. And will also align the principles, as I mentioned, with the Children and Youth Care and Protection Act where appropriate. And I'm going to outline some of those highlights for you now. The new proposed legislation will help streamline government's processes with adoptions, which will in turn increase the number of families able to proceed directly to the court to finalize an adoption. As well, it will reduce wait times for applying to adopt. It will expand the definition of a relative, and this is an important piece of this legislation, to include a parent, a grandparent, a sibling, aunt and uncle, or first cousin of a birth parent or child by birth or adoption. Now currently, what is contained as a definition of relative in the current legislation is one of the most restrictive in Canada. And relative is currently defined as a parent, grandparent, aunt, uncle, or sibling of a child by birth or adoption. So the new focus being relatives to the birth parent as well as the child, and an expansion of that definition. It expands that by adding the first cousin of the child and adding the aunt, uncle, or first cousin of the birth parent. So as an example, a birth parent's aunt will now be able to proceed directly to the court to adopt their great niece or nephew. That's currently not able or not permitted under current legislation. Prior to the Department of Child, Youth, Family Services would be involved as the adoptive parents would have to complete the Parent Resource Information Development and Training, is known as PRIDE, and also known, and they also have to complete a home assessment. So prior to this, that full process would have to be undertaking for that particular example. And I can tell you that I know that PRIDE, complete home assessment, is a fairly significant piece of work that can take a fair bit of time and work on behalf of not only the department but also the family, the adoptive family, and with this new extension of the definition of relative, has the opportunity to benefit those extended families. The prospective adoptive parent would now complete the self-help kit, and the self-help kit is available through the department's website. It's also available from our offices, and then through the self-help kit they can make an application directly to the court. And court requirements include the consent of birth parents, a person having custody of the child, and the child if the child is 12 years of age or older. It includes criminal records and child youth family service checks, a completion of the family self-assessment, and if necessary, and I understand this rarely happens, but if necessary, the court can request the involvement of the department. Significant other adoptions will allow an adoption by a person who has permanent custody of a child or who has had custody of that child under a temporary or permanent court order for at least 2 years to adopt in the same manner as a relative or a step-parent. Again, that's another feature of this new act, this new proposed bill, which doesn't currently exist in our legislation. So if a child's been in the care of a person for 2 years, either under a temporary or permanent court order, and is currently under permanent custody order, they can apply directly to the court to complete the adoption. The Department of Child, Youth, Family Services recognizes there's various forms of families, and therefore it's important that we open more possibilities for adopted children. And as an example, a court has granted a person permanent custody of a child, as I just mentioned, and the person's had that child through that court order, they can go directly to the court. And sometimes we'll see these circumstances where this arrangement is made through a private family arrangement or through a child welfare involvement, such as a birth parent being unable, not in a position to provide for the child, and agrees for permanent custody of a child to transfer to another person. Currently, the department would require the applicant to complete the PRIDE program and a full home assessment. Residency requirements. We are proposing to improve the processing timelines by removing the 6-month residency requirements from legislation. This means that a person interested in applying to adopt a child or apply to the court to have an adoption order granted will no longer need to be a resident of the province for that 6-month period prior to applying. However, the prospective adoptive parent will still be required to be a resident of the province, and the child must have lived with them for at least 6 months before the adoption order is granted. Also, this new legislation proposes provision for adult adoptions, which refers to the ability to adopt a person 19 years of age or older. The department has had inquiries from persons about the ability to complete adult adoptions. And I can tell you, and I've spoken to one individual who actually traveled to another province to carry out an adult adoption, and I know that there is a demand for this and an interest is here in Newfoundland and Labrador. With this new provision, while the department will not be involved in this type of adoption, the court will require the consent of the person being adopted, and the court must be satisfied with the reason for the adoption. Adult adoptions are frequently used for issues relating to legal permanence and for the purpose of receiving benefits and inheritance. And sometimes you'll see this when it relates to medical benefits that a person may have, and if an adult becomes their child, because of their medical circumstances, they may be able to avail of permanent or of medical benefits by the adopting parent. In addition to the in this proposed new legislation will be enhanced by improving search and reunion services for families by allowing the court, if satisfied with the reason for applying, to authorize a person to apply for adoption records where the adopted person or birth parent is not capable of applying. And this happens from time to time, sometimes for medical reason or medical situation, that an adopted person or birth parent is not capable of applying. And this new change will allow for a person to apply to the court to allow them to apply on behalf of the person. Allowing for the disclosure of the information by the registrar of vital statistics to an adopted person born in the province and their birth parents where requirements of the legislation have not been met. And for example, when a person born in Newfoundland and Labrador is adopted in another Canadian jurisdiction, the registrar of vital statistics will now be able to work with the province where the adoption was finalized to determine if it's possible to release the birth registration following an adoption. And again, our current legislation does not allow for this to take place. Allowing the registrar to enter into the information sharing agreements with other province will improve our searches and our reunion services for adopted people. As well, post-adoption services will be enhanced by allowing the Department of Child, Youth and Family Services provincial director responsible for adoptions to share information with other adoption authorities where the information is necessary for the authority to perform its duties and exercise its powers. So under this new legislation, the Registrar of Vital Statistics and also the provincial director responsible for adoptions will now have the authority to enter into agreements with other jurisdictions to better able us to assist other jurisdictions with carrying out their duties and responsibilities under their acts and as well as our own. So there are some of the key highlights from the legislation that will come to the House this afternoon.